Hi, my name is Michael Burgis, and I'm the managing attorney of MB&A. I'm a legal certified specialist in California Workers Compensation and a trial attorney. I wanted to take a few minutes to discuss some recent case law that has come out. The case we're going to talk about briefly is Galindo versus American Medical Response. This is a workers' compensation panel decision. This is a similar case as the recent holding of Reyes v. Northridge. The Workers' Comp Appeal Board is really focusing on the defendant's statutory and legal obligations under Labor Code 4600 and Rule and Reg 10109. But essentially, the fact pattern was there was a paramedic who sustained an industrial injury. He saw a psychiatrist who diagnosed him with post-traumatic stress disorder. Now, the defendant looks like they didn't do anything, and then 8 months later, they try to depose that doctor. And the applicant attorney was able to get the matter set for trial and potentially exclude that deposition, and the defendant presumptively appealed it. And this case essentially says as follows. The ruling is that defendants have a regulatory duty to conduct a reasonable and good faith investigation to determine whether benefits are due. And once again, they're citing Labor Code 4600 and Rule and Reg 10109. These are, Rule and Reg 10109 is my favorite tool in my bag of tricks to litigate because it statutorily codifies the defendant's legal obligation. And the defendants very rarely adhere to Rule and Reg 10109. And so what happens is, what the insurance company should have done is remember that Rule and Reg 10109 and Labor Code 4600, as well as the California Constitution, Article 14, Section 4, literally the workers' comp is supposed to be expeditious without encumbrances of any character. And when the defendant is put on notice that an injured worker has an injury and may be entitled to benefits, which include medical treatment, they're supposed to conduct a good faith, timely investigation to determine what benefits are due and then actively provide those benefits. Oftentimes, in fact, more often than not, that's the case here. And so this case, once again, the defendant waited 8 months after that initial finding to try to take the deposition. In reality, that deposition was probably being done to see if they can get that doctor to change his opinion and really see if they can halt the delivery of benefits or minimize their liability. But this is a great case. Once again, Galindo versus American Medical Response. And once again, this case just reiterates the defendants have a legal obligation to conduct a good faith, timely investigation. And now this case, is potentially citable and while not binding, it's persuasive, so that if you can show that the defendants have had information for more than 8 months, it's a strong indication that, at least pursuant to this case, the court should close discovery and set the matter for trial so that an injured worker can seek justice and get timely benefits. Once again, my name is Michael Burgis. I'm the managing attorney of MB&A. I strongly recommend, if you're watching this and you're an injured worker, workers' comp carriers, employers, defendants, I rarely see them comply with the law, with Labor Code 4600 and Rule and Reg 10109. The court has jurisdiction to hear if there's been a denial of care, and if there has been a denial of care, the court can potentially award that timely treatment. So if you have any questions or concerns, please feel free to give us a call. We have the answers and we're standing by. Thank you.